What that means is that if you go to trial in this case and you're found guilty, you would be considered a habitual offender, which means your minimum punishment if you're found guilty and those prior offenses are true is 25 years in prison up to 99 years or life. Do you understand?
Today's docket is a roller coaster. Second-degree assaults on peace officers, habitual offender warnings, burglary stacks, probation revocations, and a rare second chance most defendants never see. Watch for 3 pressure points. 1. Should Warren gamble on trial or take an 8-year deal after the court secures the arrest video? 2. Will Samuel's self-claimed badge number talk trigger a competency review on? How does habitual instantly raise the floor to 25 years? 3. Can Kenneth avoid prison even after pleading true to multiple probation violations? I'll translate the law as it happens, call out contradictions, and ask what you would do at each fork in the road. Buckle up. Every ruling today has consequences measured in years.
Good morning. Are you Warren Mills?
Good morning, yes, ma'am.
And Mr. Mills, in cause number 25 DCCR 0082, you're charged with the second-degree felony offense of assault on a peace officer. That's from November 19th of 2024. What that means is if you go to trial and you're found guilty, the range of punishment is between 2 years and up to 20 years in prison. Do you understand?
Yeah, I understand that part, yes.
Okay, and I have a plea bargain here on the computer that you've signed with Mr. Parker. This shows that the district attorney's office has made an offer if you wanted to enter a plea of guilty for an 8-year term in prison. You have every right to reject that and have your case go to trial and let a jury decide. I just want to make sure you understand what the possible consequences are if you go to trial, what your options are if you wanted to plea.
Yes, ma'am.
You understand all of that?
I understand.
And do you want to reject that offer and have your case set for trial?
Yes, ma'am. Yes, Your Honor, ma'am. I wanted to reject it, and then I wanted to see, at that point in time, because I was, I was incompetent at one point.
Okay.
I was out of my mind, which I have a history of it before. Full mental health.
Okay.
But I just wanted to say on docket from everybody that in my mind, my heart, my mind was so I would never hit an officer.
Well, so
just a situation that I'm in.
The allegations allege alcohol.
Here's the crossroads. The state has floated 8 years on a second degree. Assault of a peace officer is 2 to 20 if he goes to trial. The judge is pressing pause to make sure the arrest video gets to the defense. That's huge. Video can refresh memory, expose contradictions, or confirm the state's version. Warren references mental health history. That can matter for mitigation, treatment conditions, or expert context, but it does not erase guilt by itself. Allegations of alcohol or drugs can aggravate or shape plea terms. Question for you. If the video shows clear contact with the officer, do you lock in 8-nor, roll the dice on 2-2-20 with a jury?
Alcohol and drugs.
and is there a video?
That's what I was asking. I wanted to.
Hold on.
Oh, yes,
I didn't see a video on Discovery. There may be, but I don't.
I have
didn't see
a
one.
thumb drive in my file, Your Honor.
Let me do this. So before we move your case to the trial docket, I'm going to let Mr. Parker have some time to get a copy of that video. And then he can come show it to you. You may not remember everything, but maybe that video will help you understand what happened and then see where we get from there, okay?
Thank you.
If you still want to go to trial after you see the video,
Excuse me, ma'am. Your Honor, I really don't want to go to.
well, that's what,
It's kind of.
I want you to see everything. I'll give them some time to get that taken care of, and then when you come back, we'll see what you want to do, whether it's a plea or a trial, okay?
Okay.
Smart move by the court. See the evidence first, then decide. Warren hints at probation. Remember, probation on a felony depends on the charge, priors, and the state's position. Judges can't conjure it without the legal pathway and often the prosecutor's agreement. Practically, defense counsel will review the video with him, evaluate any mental health documentation, and weigh trial risk against the fixed 8. Engagement check. Would you insist on watching that video before you answer any offer? Or is an 8 ceiling safe enough to accept now if you fear a tough jury?
Okay?
Okay, thank you.
All right, you can go back with the
Can I
bailiff.
ask you one more question? You mind?
Yes, sir.
In the situation of that situation, did probation ever come across the table?
That's between your lawyer and the district
Oh, okay.
attorney's attorney. It's whether or not they offer
I
it.
wouldn't. Okay. Thank you.
Okay. I'm just going to delete the rejection if
Okay.
it's a, we'll do it again later if that's the case.
Okay.
All right? Good morning, sir.
Good morning.
Are you Samuel Jones?
Yes,
And Mr. Jones, in cause number 25 DCCR 0043, You're charged with the second-degree felony offense of burglary of a habitation. That is from November 21st of 2024. Your indictment alleges that you were previously convicted of fraudulent use or possession of identifying information, a second-degree felony, October 20th of 2021. And after that was final, you were convicted of theft of mail, a third-degree felony, December 12th of 2022. What that means is that if you go to trial in this case and you're found guilty, you would be considered a habitual offender, which means your minimum punishment if you're found guilty and those prior offenses are true is 25 years in prison.
This is the Texas habitual hammer. Once the state proves the required prior sequential felonies, the minimum jumps to 25 years, no probation, no soft landings. That's why a 20-year offer right now is paradoxically a discount against a 25-2 life exposure. Samuel says he wants everyone indicted and references a badge, number, and private detective status. None of that changes the legal calculus here. What matters are the elements, the priors, and the proof. If you were in Samuel's shoes with a second case lurking and the habitual door open due, you take 20. Or do you aim for an acquittal and risk 25 minimum if you lose?
Up to 99 years or life. Do you understand?
Mm-hmm.
And I need you to answer yes or no, please.
Yes, Your Honor.
Thank you. And I have here on the computer a plea bargain rejection that shows that the district attorney's office has made an offer if you wanted to enter a plea of guilty for a 20-year term in prison. You have every right to reject that and have a jury decide if you're guilty and what your punishment would be if they find you guilty. I just want to make sure you understand what the possible... Okay, I just want to let me finish. I want to make sure you understand your consequences possibly and what your options are. Mm-hmm. And you want to reject that offer and have both cases. And so you also have, and let me go through this too, just for the record. In cause number 25 DCCR 0232, you're charged with burglary of a building, a state jail felony. And that is from January 5th of 2025. I'm assuming those same prior offenses are alleged in that one, which means in that case, if you're found guilty and those priors are true, the range of punishment in that case would be between 2 years and up to 20 years. Do you understand?
Yes.
Okay. And you want to reject that offer and have your case set for trial?
Yes.
All right.
And I'd like to indict everybody who have witness. I'd like to indict everybody who caused this case, signed the case.
Okay.
Fingerprints, evidence, and everything. I want everything to be there.
He's complained about some charges that other counties have explained that doesn't have anything to do with here.
So here,
everybody here, and I told him everybody will have to be here at trial whenever.
Yeah, I mean, whatever the district, listen.
I want to let you know I'm 17 code, my code is 774 is my badge number. 477 Barras, Bear County, Patrol Detention.
Okay.
Private detective and everything.
Okay.
Private investigator.
All right. So here's what we're going to do before we move any further with this is I'm going to, Mr. Jones, I'm going to have someone talk to you to make sure you're competent to stand trial, get all your history, make sure we're all good before we go to trial.
Yeah.
Now, the judge orders a competency evaluation. Quick translation. This isn't about guilt. It asks whether Samuel understands the proceedings and can assist counsel think basic grasp of the charges, roles of court players, and ability to make rational choices. If he's not competent, the case pauses for restoration efforts. If competent, the case resumes toward trial. Importantly, competency isn't about unusual statements alone. It's a functional test. Your take were Samuel's claims about being a detective and getting everybody enough red flags. For your, do you see a strategic stalling attempt?
When they visit with you at the jail, either in person or on the computer, you need to make sure and cooperate with them, and then we can move your case forward, okay?
Yeah, it'll be fine.
All right, go back with the bailiff, please. Everybody keeps, y'all just wait, I'm going to get everybody. All right, are you Evan Bowden?
Yes, ma'am.
Mr. Bowden, you're charged in each of your cases with evading arrest or detention with the use of a vehicle, and what is the announcement?
Your Honor, this is a case where he also has a pending motion to revoke probation out of Chambers County. I've been trying to work something out with him. The prosecutor handling that case is Eric Carcerano, who's currently in Austin for trying a legislative issue right now. I call it.
This is.
I know, but if I plea him out to this, Your Honor, that's automatic revocation over there, and he's going to get it back. I know it doesn't affect this court, but it does.
I mean, you've been on the case since June of last year.
I know.
So here's what I'm going to do. I'm going to reset it 2 weeks.
Oh, that's fine.
And
fine. Yeah.
that is the final reset.
Like I said,
hold on. It's either going to trial or it's going to get taken care of on that day.
On Evans evading with a vehicle cases, the defense is juggling another county's probation revocation risk. Pleading here could automatically trigger revocation. The judge grants a short, final resetter, practical way to let lawyers coordinate a global resolution across jurisdictions. This is textbook docket management. Avoid a fix in Court A that detonates. Court B, pro tip for viewers, sometimes the best deal isn't in one courtroom. It's the package that neutralizes the worst domino effect. Would you wait 2 weeks to line up both Casey Zorlock a quick plea and gamble on the fallout?
On that day.
So I'm saying, the offer that the state's made, we want to accept, we like it, it's great. It's just a matter of I don't want to do something here that's going to automatically send them up there.
Well,
Once I get
I'm sure he hasn't been in Austin this whole time.
No,
so,
it's just been since
all
our
right.
last resetting.
All right.
So, yeah.
You can go back with the
But,
bailiff.
yeah, we'll get something done in that amount of time.
Good morning. Are you Ainsley Rambin?
Yes, ma'am.
And Mr. Rambin has a motion to revoke probation in one case, and it looks like 3 new cases. Is that correct?
Yes.
That's correct, Judge.
And what is the announcement?
We are working on a deal to sort of put this all under one umbrella, and that would potentially, we haven't finalized it, but would potentially involve ISF and probation. But it's not finalized. What I would ask is maybe a 1 or 2 week reset. We don't want a bunch of time. As you know, Mr. Rambin has some health issues that we're sort of consistently having to address. So the sooner we get our deal done, we want to do it, but Mr. Coleman and I need to solidify it.
2 weeks?
Enley's team pursues a combined solution, potentially ISF plus probation. ISF, an intermediate sanctions facility, is a structured short-term custody program designed to correct course without a full prison sentence. The court honors health concerns with a short reset, signaling urgency and oversight. Translation: if counsel lands the umbrella deal, Enley could avoid open-ended prison time while getting treatment, supervision, and a compliance roadmap. Question: do you consider ISF a fair middle ground accountability with services, or do you think multiple new cases should default to hard time?
2 weeks?
That's true, Judge. Yes, we'd ask for a short reset.
Okay, we'll do 2 weeks. You can go back with the bailiff. Good morning. Are you Chad Holland? And Mr. Holland's charged with fraudulent securing of documents or securing execution of documents. Mr. Gertz?
Judge, we have got the paper discovery in this case. We requested a while ago, but you haven't gotten notice of, but Mr. Coleman and I have talked about the video discovery, and so we're trying to sort that out and figure out where that is.
Okay.
Mr. Holland does not intend, we don't think, to take this to trial, absent something magical on those videos. But realistically, we want to work out a deal, but I just I have to see that before we do it. So.
Sorry to interrupt, Mr. Bishop. This case was indicted in 2023, Judge. I mean, I know Mr. Garrett hadn't been the original, he was not the original lawyer.
He was not. So I guess what I'm going to do is one last reset. If you'll just make sure and get with Mr. Coleman soon, and if there's anything that needs to be copied, I'm sure he'll get that to you quickly, and y'all can review it, and we'll get an announcement at the next court date.
Yep.
Okay.
Chad's side says they don't expect to try the case, but they need the video discovery first. That's not a stall. It's essential. Video can validate or blow up a theory of fraud or intent. Prosecutors must disclose evidence, and courts expect timely production. Defense must review it before advising a plea. The judge's one last reset is pressure on both sides. Get the footage, watch it, and come back ready. From your sheriff, the video looks bad, but the offer is reasonable. Do you take the deal? Or gamble on cross-exam to reframe what the camera caught?
Good morning, sir. Are you Kenneth Cole?
Yes, ma'am.
And will your client waive the formal reading of the motion?
He will.
Mr. Cole, on cause number 20-34802, I have a motion to revoke your unadjudicated probation. Shows that you were placed on probation April 4th of 2022 for the offense of burglary of a habitation, and that was a 6-year deferred probation. Is that correct?
Yes, ma'am.
It alleges that you violated your probation. Count 1 alleges that you failed to report in person to the Beauregard Parish probation September, October, November, and December of 2022. And is that true or not true? True or not true?
Not true.
Thank you. Count 2 alleges that you failed to report by mail or online to the Jefferson County Probation Department for May through December of 2022, and then January through December of 2023, January through December of 2024. And is that true or not true? Count 3 alleges that you didn't immediately report to the probation officer your address change. Is that true or not true? I'm sorry?
True.
Count 3 alleges that you did not provide verification of performing the community service hours as required. Is that true or not true?
True.
Count 5 alleges that you did not provide verification of entering and successfully completing the battering intervention and prevention program. Is that true or not true? Count 6 alleges that you failed to surrender yourself to law enforcement authorities in Blair, Nebraska as of January 3rd of 2025. Is that true or not true?
True.
Count 7 alleges that you are behind in your court-assessed fees. Is that true or not true?
True.
Did you enter your pleas of true to counts 1 through 7 freely and voluntarily?
Yes, ma'am.
And because those counts are all actually true.
Yes, ma'am.
I have here on the computer some documents that have your signature on them that the state's marked as exhibit number 1. Before you went over these or signed these, did you go over them with Ms. Holmes?
Yes, ma'am.
And do you fully understand them?
Yes, ma'am.
And it looks like the agreement is for me to continue you on probation and for you to enter and successfully complete the SafeP program. Is that correct? And I want to make sure probation's here. And sir, would you just state your name for the record?
Robert Bernard?
And you feel like this is the best, considering everything?
Yes.
Okay. Once out of SafeP, if I do this, where would you be living?
I have to move to Justin County.
Yeah, okay. Anything else, Mr. Smith? State tenders number 1.
No objection.
It's admitted any evidence that Mr. Cole's not competent?
No, Your Honor.
All right, Mr. Cole, you're going to get an opportunity today that you will likely not get again. Sounds like you just went away for a very long time and decided not to do anything with regard to probation. So this is your opportunity. We're going to get you some help up front to hopefully resolve whatever issues you were having, and so you can be successful on this probation when you get out. If you don't take advantage of this, then I can assure you things will not go like this when you come back. Do you understand? So I'm going to find that you entered your pleas of true to counts 1 through 7 freely and voluntarily. Find those counts true. Find sufficient evidence to find you guilty and revoke your probation, but I'm not going to do that. I'm going to, actually, the only way I'm going to do this is to extend the probation as well. I don't think it's really fair to have a 6-year probation and not be around for 2.5 years and still get 6. And so I'm going to extend your probation, which is up to me to do that anyway. I'm going to continue you on probation, but I'm going to extend that probation for a period of 2 years. You're ordered to enter and successfully complete the SafeP program as a condition of that probation. And again, if you do all of that, take advantage of it, you get out, you should be able to be successful on this probation. If not, you're going to be right back in here looking at a conviction and going to prison for up to 20 years. Do you understand? All right, anything else?
Extended for 2 years?
2. I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. Good luck to you, sir. You can go back with the bailiff. Good morning, sir. You're Corey Flemings?
Yes, ma'am.
And Mr. Flemings, and is it the same in each case, or was it an agreement for a dismissal in one? Or
It was intended to run concurrent about the 8 years.
Okay, and did you do 2 pleas? Okay, they're both here? Okay, I'm sorry, I just saw one. Mr. Flemings, in cause number 24, DCCR 2144, you're charged with the second-degree felony offense of assault on a peace officer from September 11th of 2024. That indictment alleges that you were previously convicted of possession of a controlled substance, a third-degree felony, September 27th of 2023. And what that means is that if you go to trial and you're found guilty and that prior offense is true, the range of punishment would be between that of a first-degree felony, which is between 5 years and up to 99 years or life in prison. Do you understand?
Yes, ma'am.
I'm sorry to interrupt.
Yes.
Your Honor. I believe the defendant's criminal history lends itself to being a habitual offender, and I have every intention of filing the habitual offender notice.
Okay, and Mr. LeBlanc, did you go over that with him as well?
No, you and I talked about that outside.
Oh, as far as the.
25 to 99? Yeah.
So, the state has information, he says, that you have more than one felony conviction from before. So if that's true, if you have at least 2 that are from different dates, and you are found guilty, that changes this from a first degree up to a habitual offender status, which is a minimum of 25 years in prison up to 99 years or life. Do you understand?
Yes, ma'am.
And in cause number 24 DCCR 2145, you're charged with the state jail felony offense of injury to a child, elderly, or disabled individual from September 11th of 2024. That indictment alleges several prior state jail felony offenses. And when I say several, I mean 1, 2, 3, 4, 5, 6, 7, 8, 9, 10 prior state jail felony offenses. It does not allege those prior regular felony offenses, but if you have, again, 2 regular felonies that are sequenced, not on the same day, in that case, it would make it a second-degree felony offense for punishment purposes, which has a punishment range between 2 years and up to 20 years. Do you understand?
Yes, ma'am.
Judge,
And-
I'm sorry to interrupt again. I want to correct the record. I misspoke. Mr. LeBlanc and I talked about it being enhanced to a regular first degree.
Okay.
5 to 99. We
Okay.
didn't specifically talk about the 25 to 99. I don't want to.
Y'all didn't, but you do have the prior, so it could be. Y'all just didn't discuss it.
Yes, ma'am.
Okay. So, but you understand now, I've admonished you, and you understand, and you know what your history is. If you have a prior felony, 2 prior felonies that aren't state jail, and you're found guilty, then the minimum punishment is 25 years. You understand?
Yes, ma'am.
And that's on the assault case of a peace officer. And the other range of punishment in the injury to a child would be 2 to 20. You understand?
Yes, ma'am.
Okay, and so I have here on the computer plea bargain rejections that you've signed with Mr. LeBlanc that shows that the district attorney's office has made an offer of 8 years in each of those cases to run concurrently, which means at the same time. You have every right to reject that and have your cases set for trial. I just want to make sure you understand what your possible consequences are if you go to trial, what your options are. And do you understand all of that?
Yes, ma'am.
And do you want to reject that offer and have your cases set for trial?
Yes, ma'am.
Right, we'll get it set for trial. Mr. LeBlanc will begin preparation for trial. You can go back with the bailiff. Ms. Bean, in cause number 23, DCCR 2068, you're charged with theft of property in an amount more than $2,500 with previous convictions, which is a third-degree felony, from April 6th of 2023. The indictment alleges you were previously convicted of theft September 4th of 2014, December 22nd of 2015, December 6th of 2017, December 7th of 2018, and June 24th of 2019. How do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you did what they've charged you with? And then in cause number 23, DCCR 2069, you're also charged with theft of property with previous convictions in an amount more than $2,500 from June 25th of 2023. And how do you plead to that charge? That's also alleges all of those same prior offenses. And are all of those same prior offenses true? And in this case, did you enter your plea of guilty freely and voluntarily? And because you did what they charged you with? In each of these cases, I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Ms. Holmes?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal?
Yes, ma'am.
And you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law. State tenders number 1 in each case.
No objection.
It's admitted in each case. Is there any evidence that Ms. Bean is not competent?
No, Your Honor.
Today's takeaways: Warren did the smart thing, see the video before choosing between an 8-tier offer and a 2 to 20 trial. Risk: Samuels on a knife edge with habitual offender exposure. A 20-year offer may be the lesser evil unless the state's priors or facts falter. Evans' case shows why coordinated global resolutions matter when multiple courts collide. Enley's Path ISF plus probation illustrates accountability with a treatment track. And Kenneth's segment is the rarity. Despite multiple probation violations, the judge extended probation and ordered a program. One last chance with a clear warning: comply or face up to 20 years. If you found this case as shocking as we did, hit like, drop your verdicts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.